Good morning, everybody. My name is Marty Mascari, and I'm with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC. We are once again blessed, very blessed here to have our partners at Heyman Hogue here to talk about how to have difficult conversations between parents and child, or with your mom, about planning documents. Since we see our relatives, over the holidays, a lot of times we get a chance to get together in person. It's a lot of times that's a good opportunity, and so we thought this was a good topic to bring up at this time. And so, but before we get going, and first of all, I want to apologize to y'all. I know you got your for those of you that are just coming on, I just totally screwed up this morning. I just, for some reason, had in my head that this was at 2 o'clock this afternoon, although we've done all of ours pretty much in the morning with Heyman Hogue. I don't know why, but I messed up. So I certainly apologize for the craziness this morning. But before we get rolling, Sheila, if you would, do you want to go over the CEUs for us, the CEU requirements for us? If we could advance one slide, Rex, that would be great. There we go.
Good morning. For those of you that have not joined us before, welcome. We're glad to have you. Three things. A, this is purely educational. Yes, we do this for a living, but this is an educational event. We are not selling anything. We are not promoting ourselves. We are educating you, the professionals and caregivers, to help you help others. Okay. B, this is how you get the CEUs. This will be 1.5 hours of CEU credit for nurses, social workers, assisted living managers, and LPCs of any kind, including LCDCs. So please, that is who is included here. Now, how do you do this? You will receive the sign-in sheet and the eval from Marty as a follow-up after this event. When you receive those, please fill them out and send them back to me. And it's just that simple. Then I will be happy to send you your certificate.
Great. In addition to Sheila's stuff, we're going to also be sending you in that follow-up email a link to our survey, our Google evaluation survey, which should not pop up as you close out today, because I apologize, in the mess I did not have time this morning to get that up. But we'll send you a link to our Google evaluation survey. We ask that you would fill that out if you would. That's how we report back on the goals and objectives that we set forth in applying for the funding to do these. So we certainly appreciate that. So Sheila, if you would introduce Rex and Susan, that would be wonderful, and we'll get rolling.
Well, you are lucky, very lucky this morning. Welcome to us after the holiday, or the first holiday of the bunch. And you have two of the partners of Heyman Hogue today. So this is a powerhouse team that's going to tell you how to have this difficult conversation, because it is difficult for any of us. It doesn't matter who you are. So they are going to give you some wonderful information of things to look for and things to discuss. Okay. Rex Hogue, founding member of Heyman Hogue, and Susan, who is in charge of our trust administration, our probate, and our guardianship teams. So once again, Rex and Susan.
Okay, well, we're going to talk about how to have the difficult conversation between parent and child about planning documents, and the importance of the elderly having an ICE pack and their family knowing where it is. So we're going to start by just sharing some things for you to look for. Recognizing cognitive decline in parents is important, and a lot of people get worried about forgetting names. That's not unusual if it happens from time to time, especially in a large family. But if they are consistently forgetting the names of close friends or family, that could be a bad sign. Misplacing common items, that's not unusual from time to time, but if they are regularly misplacing daily items or finding them in unusual places, finding their phone in the refrigerator or the oven or something like that, that's cause for concern.
You also need to keep be aware of daily hygiene struggles. They can lose track of time. They might forget to do the normal things like bathing and brushing their teeth and those kind of things. You might notice their clothes are not being changed, or other things that should happen on a daily basis. Weight change, especially weight loss, can be a possible problem because they might be forgetting to eat. And so things might not taste good to them anymore, or they might have issues with swallowing and chewing. And obviously, if they're not eating, then you're going to see a potential weight loss. They also might be exercising a little more than usual because they're pacing or wandering around because of their memory challenges. So be aware of those kind of things.
Balance and mobility issues, if their home is messier than usual or they struggle with certain tasks that in the past they haven't struggled with. If they shuffle when walking, that is definitely a sign. If they stumble often, everybody stumbles from time to time, but if they do it a lot, that's something to be concerned about. If they hold on to railings, chairs, furniture for better balance, pay attention. That might be a warning sign. If you see them losing coordination, that can be a problem. Reluctance to walk, changes in their gait, or obvious pain. A lot of times people will get reluctant to walk if they fear falling. And if they're unsteady, they're at risk of falling. If they withdraw or stop participating in daily activities, both in and out of the home. Minimized activity causes frailness and fall susceptibility. So learn their routine and ask about it.
And in addition to something that Rex just mentioned, I want to point out, if you've not ever noticed before, if you go to assisted livings and those kind of places where you might have some wandering issues, you will notice a black carpet area rug that might be right inside or outside of the door. You'll see that that is something that is used to protect them, because if they see a black space on the floor, it looks like a hole to them and they'll stop. So those are the kind of things to watch for. If you notice that kind of behavior, that they're stopping in a certain place and won't take a step, that could be an issue in that cognitive decline. There can also be changes in their mood and behavior. They might be experiencing anxiety or depression. They might have some sudden mood swings, be often agitated. You might notice that someone who you've known to be really smart and sharp and like to problem solve is all of a sudden struggling with those kind of things. You might see an actual change in their personality, somebody that's normally happy and just really seems angry or distrustful, paranoid, those kind of things. If they become suddenly threatening to the family, that can be an issue as well.
Another thing to look for is expired food in the fridge or no food at all. Expired medications, signs of weight loss or dehydration, bruises on their body or face. Bruises really, that can be indicative of several things, but especially bumping into things and falling and maybe not saying anything. If you see unopened mail or unpaid bills, broken items that might be dangerous, all of those are things. Cluttered walkways, both inside and outside. And one of the things that you want to do when you're there, go look around the outside of the house as well, and just see, check the garage and places where they might be out on the patio, and just make sure that it's not cluttered and, unusual. If you see missed appointments with doctors, and finding items in odd places. I already mentioned cell phone or keys in the fridge or the oven or behind the TV, or there's a lot of places. You should know what those odd locations are.
They also might not be taking care of themselves in ways like grocery shopping, getting the things that they need, maybe because they're afraid to drive now. Not preparing their own meals. My mother-in-law, I'm sure she'll never see this, just this past over Thanksgiving. She committed to making a dish, and she had to call me the day before on Wednesday and let me know that it was too heavy for her to put in the oven. And so I said, that's okay, just bring it here. And we had somebody picking her up. Well, that's unusual for her, but she's getting weaker. And so those are the kind of things that you want to look for. If they're not preparing their own meals, that's a problem. Basic housekeeping, that refrigerator, those bathrooms, things not being cleaned up. If they've got normal things that they do, like checking their bank account or watching the news or reading the paper, and they've stopped those things, that's a sign of a change. Certainly if they're withdrawing from their normal social activities and their friends and family, if they tend to not want to go to church when that's been a normal thing for them, or visit family, that can be an issue. Keep in mind, and this is something very important for everybody in these situations to be aware of, a very simple infection becomes very different as people age. And so UTI is a very common infection in older people, and it doesn't have the same symptoms that it might have had when they were younger. And so they won't realize they even have it, and then all of a sudden it'll affect their brain. And we have been through that in our family numerous times, and it really is something to look for, because it might not be a permanent decline. It may be something that's acute that needs to be dealt with antibiotics or some other medication that they'll then come back to themselves. So be very aware of that. We're taught that in our guardianship classes, that you want to make sure that we're not looking at something and thinking it's a permanent problem. Dehydration can be very common, and you want to make sure they're managing their medications okay. I've been fussed at by my mom's doctor recently to make sure I'm watching her medications, because she's getting to a place where it's just overwhelming for her.
And I apologize for clicking too quickly. Dehydration is actually common in the winter because people tend to not feel as thirsty, but we still need water. Age-related decline can happen very quickly. I've certainly seen it in my family. Older adults are determined to conceal or downplay new or worsening problems. Even a short absence can allow you to see in a new light issues that might not be obvious when you see them every day. You see them every day, and what happens is they go down so incrementally you don't really realize, but maybe your sibling who sees them once a month goes, wow, they're really going down, and you haven't really noticed. I've seen that happen. And that's why holiday visits can be so important. You get a chance to see them when you haven't seen them in a while, and you can compare to what you saw the last time you saw them. Walk through their home for anything that seems unusual. And again, walk outside areas too. It's funny, the things, I won't take the time to share the stories, but I had a grandfather that had both Parkinson's and Alzheimer's, and he did some really unusual things that we got a laugh out of, but they also indicated his decline.
So if you start seeing things that concern you, then you need to start talking to them about the ice pack. The earlier you have that talk, the more likely you are going to succeed, because the further that they decline, the more stubborn they can get and the more in denial they can be. If they are no longer competent, if you get to that place, then it may be too late for planning. And so you don't want to wait too late. Rex has this fake phone number that you can call, but you really don't want to wait too late. One of the most common things we get is calls from people who have been told by the nursing home that their mom stays at, or assisted living, or somebody like that, you need a power of attorney. And unfortunately, it's very common that by the time they call us and tell us that, a power of attorney is not an option anymore. And so you don't want to wait too late, and you don't want, if you're dealing with people that are in this situation, you want to make sure you give them plenty of information to warn them so they can address it with their family members early enough to do something.
So what should be included in the ice pack? Well, I've got a list here of several items, a copy of their driver's license, social security cards, their medical cards, Medicare info, Part D description, prescription drug coverages, a list of medications and other pertinent information about their health care. They ought to have a list of medications that they're taking, and make sure that you know what that is, because if you're needing to talk to a medical professional, you need to be able to relay that. Their emergency contacts, especially for doctors and other medical providers, you need to know how to reach those folks.
You want to make sure that there's good contact lists for relatives, friends, neighbors, anything that someone would need to pick up and take care of if they couldn't. Financial advisors and CPAs, certainly their attorney information, insurance agents, all the things that are here listed on this slide. It's really important that that information is there. And then also a list of normal bills that are paid, debts that are outstanding, how things are paid, if they've got automatic payment coming out of their bank, or if they're still writing checks, those kind of things, customer service information. And then of course, any kind of insurance information on their life, their health, their disability, home insurance, auto insurance, all of that needs to be readily available. Then also we've got the financial accounts, their bank accounts, their savings accounts, their investments, those kind of things, and who the contact people are for those accounts, so that if somebody else needs to start to pick up where they left off, they've got people to contact.
Also information about accessing electrical devices like their phone, their computer, their TV, their internet, anything like that. Somebody needs to know how to do it. And you know what? If they haven't done it, take the time to write it down. Information on online accounts, email, and social media. Sometimes they can be very secretive and not wanting to give out information about bank accounts, but somebody should have the authority, and that's one of the things that should be included in their ICE pack. A list of assets and valuables, their homes, their cars, storage units, jewelry, artwork, electronics. One of the issues that we run into in estate administration, and Susan, you can kind of address this because you deal with that. People don't know where stuff is.
Right.
You know, Dad, he's got a piece of property, but I don't know where it is. It can take a long time to find that kind of stuff. List and contact info of all organizations such as church, alumni, professional, licensing boards, anything that they're a part of, even social groups. Really, somebody needs to document their life, and they need a complete estate plan. Trust me, by the time you're calling the law firm asking for a power of attorney, you need a whole lot of other documents. So
what happens if there is an emergency? Is somebody going to be able to get the information about you in a medical emergency? Is somebody going to be able to help you in a medical emergency?
And these are questions you can be asking them.
Right. Is someone going to be able to make medical treatment decisions for them if they're in a medical emergency? These are critical questions, and if the answer to any of them is no, then there's going to be problems.
Effectively, if they have no legal documents, what you have is no legal authority, and your family has no more right to obtain medical or financial information about you than they would a stranger on the street. And we have laws like the Health Insurance Portability and Accountability Act. You can't even get medical information about your own kid after they turn 18 without a HIPAA authorization. And that applies to elderly family members as well. You can't get information and make intelligent decisions without that documentation.
So that HIPAA patient authorization is one of the first documents you want to make sure is included in their estate plan. You also want to make sure that medical power of attorney is there, giving someone, an agent, the ability to make medical decisions if they can't. Something important to know about that power of attorney is that it's not, it doesn't kick in until you don't have capacity and can't make your own medical decisions. Now, a doctor is going to be the one to be able to realize, maybe this person is able to talk to me, but they're not making rational decisions. And so that's an important thing to have, to be able to, an agent to be able to step in and make those critical decisions. Personal and healthcare instructions are very helpful. It's a supplement to that medical power of attorney, not necessarily a legal binding document, but a packet of information that the person can say, in this situation, this is how I want to be treated. And the more of that you have, the easier it is on the agent to make those decisions in accordance with how the patient would want to make those decisions. Then a directive to physicians and family or surrogates. This is very commonly known as a living will. And what it is not is also very important. It is not a DNR. DNR stands for do not resuscitate. That is very different from a living will or a directive to physicians. And so you want to know the difference between those documents. Generally speaking, attorneys don't prepare a DNR. That usually is going to come from healthcare professionals, oftentimes a hospice agency of some sort, or a doctor. And that document specifically says, do not treat me if certain things happen. Let me go and do not put me on life support. But a directive to physicians and family or surrogates, a living will, is an essential part of an estate plan, because that makes the patient's wishes known when it comes to life support, end of life decisions. And it really is, after all hope is lost, then what does the patient want? Do they want to remain on life support? Do they want to be taken off life support? And so that document is really important for the family to know what their wishes are. And then there's also an anatomical gift form that can be used to say how they feel about donating organs, whether they want to or not, whether they want an autopsy that's not required by law. There's some very important decisions that are made in that document. And so it's a good document to have as well.
A lot of people are reluctant to sign that because they think by signing it, that means they're making gifts, but there should be an option to say, no, I don't want an autopsy. And if you don't sign that form and fill it out, somebody else has to guess.
Well, and even on that anatomical gift form, what we get a lot of times is older people saying, oh, there's nothing for, that anybody would want of mine. And that there's a really cool thing to know about donating your eyes. There are children, babies in other countries, and medical staff that will go and do certain medical treatment for them, and any eyes are good because they can see something, and these children are given sight even when the eyes are, in their 70s or 80s or older. And so I always encourage my clients not to let that be the reason, but it is something that we hear a lot, and you'll hear that a lot from people, is that they don't have anything worthwhile.
And in case you don't know, we're all born with an extra vein in our leg that doesn't get used unless we undergo open heart surgery or something like that. And somebody who's 100 years old who's never had that, they have that vein in their leg that is still usable.
Yeah.
So, yeah.
Not a good reason. Age is not a good reason not to do it. There's all kinds of good reasons,
Right.
But that's not one of them.
That's not one of them.
And then another good document to have is appointment of disposition of remains, appointing an agent that will determine what happens with your remains after you're gone. And that person should also know what your wishes are with regard to that, but at least have someone that a funeral home can talk to. So how do these documents end up getting where they are needed when they're needed, like at the hospital or with a healthcare professional?
Well, that's a great question. We like a company called DocuBank. DocuBank will keep those documents on file, and they can fax them or email them to any hospital in the world 24/7, 365. We've even had clients use them at 2:30 in the morning on a Saturday. And they give you a little emergency medical info and medical directives card that goes in your wallet. Medical professionals know to look for that. It's got the number they can call. It says who the agents are, how to reach them, and even who the law firm was that prepared it. And that's just very valuable information to have in an emergency.
And it's one of several companies now. It's one of the early ones that has been doing it for a really long time, but there are a lot of companies out there that do this now, and it's a really good, good thing to know about.
Yeah. So how do you get a substitute signature when you cannot sign your own name? All estate administration revolves around this single issue, because if you can sign, you don't need a substitute signature, but if you can't, that becomes a problem. And I refer to this as the first planning dragon, the administration dragons, and everybody has administration dragons. So is somebody going to be able to pay your bills?
Right. No, that's you.
Okay. Talk to your mortgage company or landlord, the utility companies, loans, the manager at your bank account or finances. Are they going to be able to manage that? Are they going to be able to break or apply for a lease? Can they sign tax returns or tax documents on your behalf? Are they going to be able to apply for government benefits or conduct financial business of any sort on your behalf? Are they going to be able to sell your house if money is needed for your care? And it can get even worse. What if you become incapacitated, requiring a legal guardianship, which is a very expensive legal process? The bottom line is, if you don't have the documents that allow people, give people the authority to do that, documents that will be respected by those third parties, you're looking at potentially a guardianship. So there's three ways to deal with incapacity. The first is powers of attorney. With a power of attorney, the principal gives the agent a power of attorney. It's an invitation to third parties to let that agent act on their behalf. Folks, think about this. What are the two things you can do with an invitation? You can accept it or you can reject it. Why would they reject the power of attorney? Well, a couple of big reasons are, you're not there to tell them it's okay to take it. They don't know if you might have revoked it. They don't know if you're even alive. And if you've died, that power of attorney died with you. And for that reason, institutions are very reluctant to take powers of attorney. They want some assurance that they're not going to get in trouble, because I can tell you, banks don't make their money by paying money to your agent to do something and having you walk in the next day and saying, I revoked that a month ago, because they're going to put their own money back into your account. That is not what they get paid to do. If the power of attorney doesn't work, then I ask people, what is your plan B? It's either a guardianship, which I define as the court supervised management of assets for somebody who's legally incompetent. Some people refer to it as living probate, or a living trust. It can replace the powers of attorney. It can provide that necessary substitute signature without going to court to get it. It avoids guardianship and probate for assets that are in the trust. And it can even provide instructions for an incapacitated trust maker's care. And I may share a story on this a little bit later. But tell us about guardianship, Susan.
So guardianship is a process in court that is going to deal with any assets that are individually owned by the incapacitated person, and any form of ownership that they might have in an asset. Even if there's several owners, if one owner is incapacitated, then we're going to have an issue that's going to take us to court to deal with that asset. And so we've got, in Texas, we have two parts to guardianship. We've got guardianship of the estate, which is a very difficult and costly process. And then we've got guardianship of the person, which is still difficult from an emotional standpoint, but not nearly as difficult when it comes to managing or being the guardian of a person. Guardianship and probate, they're caused by the same problem. We don't have a person who can sign. Either they're incapacitated or they've passed away and they can't sign the necessary documents to transfer assets. And so guardianship and probate solve that problem by having a judge authorize someone to be that substitute signature. They are ways, and frequently one of those might be the only solution to the problem. But is it the best solution? No, because guardianship has a lot of issues that come along with it. First of all, it takes a lot of time. When you apply for a guardianship in a court, it's months, usually months, before you actually have it in place. It costs a good bit of, it's got a high financial cost because there's at least 2 lawyers involved. First of all, whoever is applying to be the guardian has to go to an attorney to have that done. They can't represent themselves. And the court then is required by law to appoint a guardian for the proposed ward, the incapacitated person. And there's a really good reason for that, because the law is there to protect those people from being taken advantage of. And so, so there's a second attorney that's independent of the application lawyer or the guardian's lawyer that is looking out for their best interest. And actually representing them as an attorney. Oftentimes, well, there's always going to be a doctor involved. That can have some cost with it. There's going to be a social study that's going to be done of the situation. And then there's a lot of going to court. Sometimes you get lucky and you have one hearing, but it is not unusual to have more than one hearing, especially when we're talking about guardian of the estate. Loss of control, because this is the court supervising, and that supervision doesn't look so bad when it comes to guardian of the person. It's an annual report to the court letting them know how they're doing. But when it comes to guardian of the estate, the court deals with every penny that goes out of the estate of that incapacitated person. And even though it may be your mom that you love and are only going to do the best for, you've got to get the court's permission to spend 1 dime on her. And so that control is very invasive. Certainly a loss of dignity, because we've got this person coming into court, we're having to declare them incapacitated, and that emotional toll can fracture families. So that's never fun. And then we've got a major asset protection problem. Once we get into a guardianship, same for probate, it opens the door for creditors and predators. That door is shut as long as everything's private. But once it ends up in probate court, then it's out there in the public record, and anybody can access that public record. And so that's never a good thing.
Yeah, one thing that a lot of people don't realize is there is a 100% chance their case will be heard in the probate court if they want it to be heard. But if they have to go sue in district court or county court, there is a very low chance, anywhere from 1 to 5% chance, that case will actually see the light of day in the courtroom.
So we're going to talk about a couple of situations that have come up in my practice, just to give you some examples of how things can go wrong. Ellen had a lifelong struggle with what her family suspected was mental illness, but right on the edge, so manageable. As she got older, she hit 90 and it started becoming violent. And she was a firecracker. She didn't weigh 90 pounds, but you know, she was doing crazy things like accusing her 90-year-old husband of having an affair with the maid and pointing a shotgun at him and throwing things at him. And so things started to get worse as she aged. She had never trusted doctors in her lifetime. And so when her family realized something had to be done, and it was the children, the 60-plus-year-old children that were realizing this was an issue, you know, one of the things they knew was they needed dad to be able to manage some things, and the kids needed to help too. And so when they went to an attorney and asked for a guardian, the first thing that would have to happen was an exam, a mental exam to determine her diagnosis. I was the ad litem in the case. I represented this little firecracker and talked with her, and she definitely had her opinion about things, but she wasn't rational, and she wasn't going to voluntarily submit to a medical exam. So the family actually, and they wanted to back out. They wanted to back down and say, never mind, this is too painful. But by then I had been appointed, and I said, no, you can't, because I'm here to look out for her best interests, and she's a danger to herself and other people. And we need to move forward with this. And so they had to go sign an affidavit claiming and stating that she was a danger to herself and others. And then she had an arrest warrant was issued for her. Now, thankfully, the local police department was smart, and they handled it as well as they could by having paramedics go out and take her in an ambulance to a psychiatric hospital for evaluation and treatment. But that was difficult because, remember, she doesn't trust doctors, and now you're going to force her to get in an ambulance and go to a hospital. It was extremely traumatic and painful, but could not be avoided. And so we went through that very difficult process. If she had had some documents in place, medical power of attorney and some things like that, it might have been avoided. But because she didn't have documents in place, we had to go through several different things to take care of her estate as well, and make sure that somebody could manage her assets. And so it was a difficult process to go through. Another situation that we had recently, we had a client whose mother had moved from out of state, moved into Texas to be near her children after her husband died. And she was very lonely, and she met a man online. There is something out there, if you hadn't heard about it yet, called a romance scam. And it's terrible. I mean, these widowed ladies and gentlemen end up on the internet, and they think that they've fallen in love with someone that they've met on the internet. This lady sent over $900,000. She had a large estate, and it's gone. I mean, almost all of it's gone. It was figured out when she started to try to sell her house, and then finally her kids realized what was happening, and most of the damage had already been done. She was selling family heirlooms. She was doing anything she could because this man that she'd fallen in love with was going to marry her and move her out to Florida and buy a new house for them. And she just could not understand that it was a scam. She wasn't to the point of Alzheimer's or dementia. In her normal daily activities, she could live alone, she could take care of herself, but she couldn't manage her assets because she was giving them away to a con artist. The guardianship in that case is still going on, and it's been going on for over a year now. And she's got a guardian who's trying to watch out for things, but every chance she gets, she is trying to sell things to send to this man. And they have not been able to stop him because, of course, he's not in the United States, not anywhere where we can reach him. And the guardianship itself, just the attorney's fees, has been $40,000 plus. Then this third situation were some clients I had in. The family came in just in time. They recognized that dad was depleting assets because he was giving them to a wayward son who just never could get his feet on the ground. And there were 3 kids, and the other 2 recognized what was happening, as did Tom's wife, Shirley. And so they were worried, and they wanted to see what they could do to stop the behavior. So Tom and Shirley came in and sat down and talked with me about their estate plan, and I was able to honestly talk with Tom and help him understand that he was depleting assets that he and Shirley might need in the future, so that they wouldn't be a burden on their kids. And so he agreed to a plan where he no longer had direct access to assets that were, the bulk of the assets. And so we put that plan in place. We did a living trust for them, and we made the other 2 kids trustees over the bulk of the finances. And that was, that put everybody's mind at ease. And then 2 months later, he was unable to manage his finances at all. He'd been in the hospital 6 or 7 weeks. So then the family called me and said, what do we do? Because he was still trustee over certain things. And so we're in the process of removing him as trustee. We don't have to go through a guardianship for him because he was in agreement, and we caught it before it got too bad. And we were able to get a plan together to be able to have the right instructions in place on exactly what to do in this situation. We've avoided the courts, we've avoided guardianship of the estate, and very high, potentially high attorney bills.
We're now going to look at a case study and show you this situation from where they were, and then what if they had done a different kind of planning. Carl and Myra, both elderly, they have 3 children, Peter, Paul, and Mary. Myra is terminally ill. She can't manage assets or herself. She knows it. And Carl has Alzheimer's, and he recognizes that he can't really deal with things. Their powers of attorney have failed. Institutions refuse to take them. They have a $500,000 home. Carl has a $500,000 IRA. They got $1.8 million in investment accounts managed in Carl's name, $200,000 in joint bank accounts, and their old powers of attorney are no longer valid. The law has changed. And by the way, laws do change on powers of attorney from time to time, and there's been several changes in the last few years. So what we need to do in this case is get assets to provide for both Carl and Myra. We've got to sell the house because it's no longer feasible for either one of them to live there, and they both know that. They need funds for Myra to be in a facility, and Carl is better off in a facility. He knows it, and they started this process a year ago. Well, got to get a doctor's report on both of them, hire an attorney to file 2 different guardianship applications proposing Peter as the financial guardian. They have to notice interested parties, in this case the kids, and they all live relatively close, so that's not a huge deal. And the court appointed the same guardian ad litem for both cases. Now that doesn't always happen, but it did here. The court didn't have to do that. And the problem is neither Peter nor the other kids have any access to financial info or assets, but they do have info from statements they found at the house. But that's a very difficult way because some statements might only come out quarterly, and it can take a while to figure out what all you have. The court investigator does a background check on Peter, and the courts are backlogged on background checks. That particularly happened while COVID was going on. Peter has to qualify for a bond, and the reason they selected Peter is he was the one who could afford to do it. That bond is up to 3% of the assets. They have about $3 million. That's $90,000. Now, if Peter didn't have that kind of money, what would happen then? Fortunately, Peter could do that, but he has to pay for that bond. He can be repaid in probate, but we don't know how long that's going to be. So he may have to ride this out for years. He's going to have to undergo training to get approved as a guardian. There's a course that he has to take. And Susan, is there some kind of test for that class, or do you just have to prove you took it?
You just have to prove you took it to have a certification.
Okay. Now, guardianship, I tell people guardianship is one of those 12-step programs. There literally are 12 steps to the process. The minimum cost of a high net worth guardianship, Susan's already alluded to this, is $40,000. But in this case, it's each. They're going to spend $80,000 getting the guardianship on these 2 people. And it could get worse if there are creditors or predators hanging out there wanting money. The annual cost is going to be a minimum of $10,000, but it's usually going to be more because there are annual reporting requirements. And it seems like a constant stream of surprises that goes on for as long as the ward is alive. And the ward is the person who's been declared by the court to be incapacitated. This is disastrous for otherwise good estate planning, business planning, and asset protection planning. Well, Carl moved to the same facility as Myra a year ago. And even though in 2020 it was possible to waive the RMDs in Carl's IRA, Peter could not get the authority to do it in time. And you can now tell this case is at least 2 years old. But that meant Carl had to pay unnecessary taxes. And just was an unnecessary expense. But that's because nobody had the authority to do that in 2020. Now, now the guardianship is in place, we're now going to compare it to what would have happened if Carl and Myra had done planning. So we're going to say that they did a trust right after Myra was diagnosed 3 years ago. Carl was not yet showing the signs of Alzheimer's. How is a typical trust going to work, assuming they get the assets transferred properly? Well, the assets will be in the trust, and when Carl and Myra can no longer manage it, Peter, Paul, and Mary were named as the guardians, as the trustees, and they could all manage it together. Now, not all trusts are the same, but in this case, it worked well. And one of the things that was important is the definition of incapacity, because that's what allows an institution to accept the kids serving as the trustees. Myra felt it was best if Carl served with Mary for her, and Carl preferred Peter to serve with him. And that's really not unusual. Parents don't always see their kids the same way, or they may be closer to one than the other, or there can be a lot of reasons for that don't have anything to do with family disputes. They compromised and had Carl have a 40% vote, serve with Peter, Paul, and Mary with a 20% vote each. So Carl and any one of the kids could control this. When Mary needed a facility, the trust provided suitability instructions for her care. And I'll share this story. When my mom had to go to a facility 300 miles away, she wanted to go to an independent living facility. And I sent my brother a checklist of the facility features Mom wanted, and it took him 20 minutes on the internet to find 2 places within 10 minutes of his house that met all of her criteria. And instead of the 4.5 months my brother thought it would take, she moved in 23 days. That's the power of having those kinds of instructions. Well, same thing happened with Carl and Myra. They picked a place that was closest to Mary, since she had a little more time and she lived closest to them. Once Myra was in a facility, the kids took care of the bills. Neither Carl nor Myra ever had to worry about financial stuff again. Carl could spend time with Myra, and Mary realized Carl couldn't stay at home. The kids did serve as the incapacity panel, and that meant that they could privately determine that Carl was incapacitated when he started showing signs of Alzheimer's. And they were able to remove Carl as a trustee when that became necessary. They did not have to remove him because third parties by that time were already used to dealing with the kids. And when my mom became unable to manage assets and she kind of lost it mentally, my brother and I were already serving as co-trustees. They've been used to dealing with us. My mom didn't touch a bill from the moment she got in the vehicle to drive down to San Antonio from Irving. Kind of the same thing here. The kids had been doing everything and nobody questioned it. They can move Carl into the facility without a doctor's statement. The trust instructed them to use the same facility and even put them in the same room. Folks, I got news for you. If those kinds of instructions are not in the trust, that may not happen. They were able to avoid the unnecessary RMD in 2020. The RMD, the required minimum distributions in the retirement plans. No fuss or issues with any third parties to handle things that way. So Susan handled the first part of this, so I get to handle the fun part. Guardianship or a trust. Let's see what a trust does. Incapacity is still an issue, but look how different the rules are. The assets are managed by the trust terms. The trust itself provides for that substitute signature. It avoids guardianship. It replaces the powers of attorney. Here's the thing, an institution can refuse the power of attorney. They cannot refuse to deal with the trustee. The trustee holds legal title to the assets. It's a huge difference in their authority. They also are not on the hook if the trustee messes up. The trustee is the one that's on the hook. And so you can imagine that they're glad to do that. Absolutely. It's easy to manage, change, or update, but it works best when the assets are fully aligned with the trust. So what is a trust? It's a contract that involves three parties: the trust maker, they go by other names, the trustee, and the beneficiary. The trust maker makes up the rules in the game. In the example I just gave, that would be Carl and Myra. The trustee, they could appoint themselves as trustee. That's not what they did, but they could have done that. And they're the beneficiary. So what happened with my mom? When my mom became incapacitated, my brother and I remained as trustees, but mom was the beneficiary of that trust. And we were required to manage that trust according to the rules that she set up for her as the beneficiary. And we weren't heroes for doing that. That was our job. We just carried out what we were supposed to do. And it's typical in a revocable trust for the trust maker to serve in all three rules. The vast majority of our cases, that's what happens. The trustee holds assets for the trust. That's often stated as a trust owning the assets. For our purposes today, we'll pretend that the trust actually owns it because that's the effect of it. Assets that are in the trust do avoid guardianship and probate. Now, while a person is alive, the trust avoids guardianship for assets in the trust, provides instructions for care in case of incapacity, can give you a chance to see how successor trustees manage assets. That can be important to some parents. It's easy to manage, change, update, best if assets are fully aligned with the trust while that person is alive. And what we mean by the assets being fully aligned is your bank accounts are owned by the trust. Real estate is titled in the trust name. The trust is the owner and beneficiary of life insurance, brokerage accounts, and that kind of thing. So here's a couple of examples. Teresa was approached by yet another stranger for a $5,000 donation. Now, she was no longer the trustee, her kids were. So Teresa told her kids, hey, I like this organization. I want y'all to donate $5,000 to it. And they said, Mom, we'll get it taken care of. But they knew that Teresa was not mentally capable of doing that. She had never given to a similar charity. So her suspicious children did not donate, and she forgot about it by the next day. She never asked them about that charity again. Think about that compared to the guardianship cases and how much easier having a trust is. Another case, Dale enjoyed going out to eat, and he had always been frugal, but he suddenly started leaving large tips. And I mean, he would go out and eat a $15 meal and leave the waitress a $100 tip. Okay, if he was wealthy and just very generous, that's one thing, but he didn't have the kind of money that would allow that to go on forever. So his son removed his access to the bank account. And what he did is he told Dale he would pay for meals via credit card. So all Dale had to do is call his son, and his son would pay for the meal. And Dad would tell him, give a $100 tip, got it taken care of, Dad. And Dad didn't realize he would give a nice tip, but he wasn't being outrageous about it. He had ordered large tips, but they paid reasonable tips. And compare that to a guardianship or the case of the lady who just spent hundreds of thousands of dollars on a non-existent lover. A trust works so much better. Julia loved online shopping. She forgot what she already had. Well, when she moved into a facility, the kids found 250 pairs of pants. 73 of them still had tags. Yes, this is a real case. I didn't make those numbers up, but they had no receipts. They couldn't return them. So the kids cut off access to her accounts. They brought her clothes, and they were really kind of clever about it. They brought her a few new clothes and showed her the tags. She said, oh yeah, this stuff that I told y'all to order. She couldn't even remember what she had told the kids she'd ordered, but she already had it. And she appreciated the care that she got from her kids, not realizing that they really were just giving her the stuff that she already had, and they would rotate the clothes out. Yes, this was someone I actually knew. So compare this to a guardianship, particularly where she might have access for months to just keep spending money that she didn't need to spend. She had plenty of it. So what do you think the best way to deal with a guardianship is? Is it a guardianship? I'm sorry, incapacity. Is it a guardianship or a trust? I've never had anybody who's been through a guardianship tell me guardianship was a good way to do it. So in estate administration, when a person dies, everything goes into what I call the estate settlement cost funnel. There are several types of expenses that come out. The first is administrative expenses. You remember a while ago I talked about administrative dragons? You're always going to have administrative expenses. My questions are, which rules apply? How many different rules apply? And where do you put your family in this process? Another type of expense that comes out is probate. Now notice that probate and these next two are outlined in red. Here's the reason. It is possible to plan to avoid probate, and even if you're not 100% successful, probate over a smaller amount of assets costs less. Creditors or predators. And then taxes. Now, not everybody has tax issues, but there's more than one. And if you have to file an estate tax return, the administrative costs are going to increase significantly, and the estate tax return is known as Form 706. And then after these...
Can I stop you right there, Rex?
Sure.
And the Form 706 is something I do a good bit of. Having a trust doesn't mean you won't have a Form 706, but it's going to be a lot less expensive process if you're not having to go through probate and some of the other things to get to that point. And so that is something we see in our high-end clients, is that they do need a 706, but it's going to be less expensive if they're not going all the way through probate and other things that they've got to do.
Yeah, and I'll just go back and point to the creditors there. In great big cases, you're more likely to have creditors pop up out of the woodwork. Mm-hmm. And if somebody is filing a 706, trust me, there's enough money there, and the more creditors or potential creditors or predators know, the more likely they are to make a claim. So that's a really great point, Susan. And then the family gets what's left over. So there's only 4 ways that assets pass. Joint with right of survivorship, beneficiary designation of some form, it's owned by trust, or it's owned by an individual. So we're going to take a quick look at how these work. So the first thing we do with every asset is we check and see, is it owned jointly with right of survivorship? And if so, it passes directly to individual survivors. I call beneficiary designations planning by the box. There's a box on a form that says, if something happened to you, where do you want the assets to go? And whatever you put in the box, that dictates the rules. And if you put an individual's name in the box, you're now playing by the same rules as you are over on the right of survivorship. Now, if it isn't a beneficiary designation or a transfer on death or pay on death designation, then it may be owned by a trust. But I forgot to tell you, With right of survivorship and beneficiary designations, you have no control over what happens, and they will both blow any tax planning you may have done. And you may think, well, I don't have an estate tax problem, but you may have other tax issues that you don't want to blow that.
And before you move on, just the reason there's no control, and quite honestly, this is how most people do their estate plan. They designate beneficiaries, they do right of survivorship accounts, and they think there's not going to be a probate, everything's going to go directly. But what they don't know is the condition of their beneficiary when they pass. If a husband and wife own a joint account and they're in a car accident and the husband dies and the wife's incapacitated, what do we know is going to have to happen at that point? She's going to have a guardianship in order to manage the assets that she now is in charge of. And other things like your children going through a divorce or having creditor issues, all those things are unpredictable. And that's why you think you have control, because it's easy. It just goes to the next person. But what if there's a problem with that beneficiary? So that's why we say you don't have control, because you don't have control over those circumstances.
Yes, and if it's owned by a trust, it will pass according to the trust terms. Now, beneficiary designations can designate the trust as the beneficiary. That doesn't solve incapacity issues, but it does solve the on-death issue, and the trust controls it then. If it isn't owned by a trust, the only thing left, it's owned by an individual, and it goes through probate. And there it's controlled by the will or intestate succession. Intestate succession, in case you don't know, is the will our state legislature has graciously written for you in case you either didn't write one or yours is invalid. Now, if you have a trust-based plan, we use what's called a pour-over will, and it pays assets to the trust, so the trust terms still control. Now, all of these, and the box, the default on the box, if everything goes wrong, is the probate estate. So all of these get assets to beneficiaries, but they're not equal in the way they do it. So let's take a quick look at the administrative rules. So first, you always have to look at case law, banking regulations, the Internal Revenue Code, and the Treasury regs. With right of survivorship and beneficiary designations, you have a common set of rules. And in each state where you have owners, survivors, beneficiaries, or where assets are located, you're going to have several other laws that come into play. Make a note that under the Internal Revenue Code, there are special bad tax rules that apply. And in case you want to know what they are, it's section 1014 of the Internal Revenue Code. Other laws that can come into play is either their estates or probate code, the property code, the insurance code, or the family code. And I'm going to show you a case where this stuff came up. With the trust, we have one set of rules, the state's trust code and the trust itself. If it's owned by an individual, you go through probate in each state where there is a real property interest. Now, in Texas, for example, real estate and mineral interests are real property interests. In some states, mineral interests are personal property interests and don't go through probate. But in those states, you're going to be controlled by the probate code and the property code, and there could be other things that come up. So overusing right of survivorship and beneficiary designations is very common. Now, probate technically means to prove up the will. That, in my opinion, is not the ideal definition because regular people don't know what that means. I prefer the layman's definition, the court-supervised transfer of assets for somebody who's died. People want to know how much does it cost and how long does it take. I'm going to give you a little hint. If you call a law firm and ask those two questions and they give you a straight answer, they will lie to you about other things. It is not possible for them to know that. They might know what their fees are, but that's not really what people are asking. What you should ask is who gets paid first and who controls the process. Okay. So the first thing that's paid under the Texas Probate Code is funeral and last illness of $15,000 each if the court approves. Now, when you see language that says if the court approves, the way courts approve things is lawyers go to the court and argue it. That's an expensive way to prove stuff. I've got a case that I'll get to that sort of addresses that. Family allowance for up to 1 year if you have qualifying family members, that's usually surviving spouse, incapacitated adult children, or minor children. Then comes the cost of administration. I tell people this is our favorite part. It's where attorney's fees are paid. Court costs, executor fees, preserving, safekeeping, or managing the estate, and unpaid guardianship fees. Susan, let me ask you a question about that though. Are attorneys really third on the list? Or do we get paid before we file the case?
We get paid up front, and
Yeah.
sometimes that means it's out of pocket for somebody and they have to get reimbursed later.
Yeah, so we only let the funeral directors in hospital think they're ahead of us.
Yeah.
Secured claims and tax liens, unpaid child support and interest, taxes, penalties, and interest. Good to hear all that cheering in the background because that's the IRS. Look how many people Texas puts in front of the IRS, and we get away with it. Cost of confinement if a person was in jail or prison, repayment of medical assistance if they're on Medicaid or something like that. And then finally, other claims. And I'll give you an example. I had a case a few years ago. A landlord owned property in his own name, signed a lease, and right after his renter moved in, the landlord died. Well, the kids had to go to probate, and it took, just due to multiple issues, it took over a year before they could get to the hearing. So this is what the renter told them. I'm supposed to pay John Doe. I will pay the estate of John Doe as soon as you show me documentation for it. I'll set the money aside, but I'm not paying rent to y'all because I'm not authorized to do it. Well, for a year, they didn't collect rent from him. They still had to pay taxes. They still had to pay insurance. They still had to pay repairs. And then they finally got the authority, and the renter wrote him a check for all the back rent, no interest or anything, and then told him that he would sign another lease for the same terms for the next year. Well, boy, they just felt like they didn't have any real choice. That was a huge problem to the kids. Did you notice who's not on the list? It's your family. They are last on the list if you go through probate. And even though Texas has arguably the best probate system out there, your family is still last on the list. Now, do you know why I said, where do you put your family on this list? If you don't want your family to be last on the list, you definitely want to avoid probate. Now, who controls this process? Well, I wish I could tell you it was the lawyers and the courts. If that was the case, probate would be way faster, but it isn't. It's people from every step except generally 3 who might make claims. Nobody knows who's going to make claims. Nobody knows how long it will take to resolve those claims. Nobody knows what it will cost to resolve those claims. That's why they can't tell you the cost of probate, and that's why they can't tell you how long it will be. You're also subject to court schedules. So I will give you my definition of probate. I have given this to 3 different probate judges and have yet to have one disagree. It's a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. I have yet to have anybody say that's who they wanted to protect. So I got another case study for you. Marlene owned 3 children, had 3 children, Harry, Don, and Norma. She died on a Sunday. 8 days later, her daughter Norma came to us to probate her will. Now, how assets pass is important. 50% of the assets paid by right of survivorship, TOD, or POD. These are all financial assets. 30% passed by beneficiary designations, again, financial assets. 20% passed through her will. She had a home here, she had a property in Wisconsin. Both of her sons were in second marriages. Norma, her Texas child, is in her first marriage. She has kids with her husband and no issues there. And she wanted to probate because the real estate market was so hot here. And I know because about this time I sold my mom's house. We put the house on the market on Thursday afternoon, just after 5 o'clock. Monday, 4 days later, I talked to our realtor. And he said, Mr. Hogue, I've got some bad news for you. We've only got 7 offers on the house and only 6 of them are above your asking price. I said, boy, give me more bad news like that. But they can't sell the Texas real estate until after the Texas probate. They can't sell the Wisconsin real estate until after the Texas probate and then the Wisconsin probate. 80% of her 1/3, Norma gets outright within a month, but no protection. And we're going to address the no protection in another case. Harry, he lives in Illinois, second marriage. He had minor kids prior to the marriage. His mom did not like his new wife. He died 10 days after his mother. Now, 80% of his 1/3 passing by right of survivorship, beneficiary designation, or TOD, look what happens. Right of survivorship vests in 5 days. That is the law in both Illinois and Texas. And yes, we had to look at both here because he lives in Illinois. Beneficiary designations and TOD vest immediately. Harry has a simple will with his new wife, all to her. He hadn't gotten around to planning yet. That means 80% is going to go to her. What about his minor children? What a disaster. Now, 20% from the will, he did not survive the 30 days required. So the good news is for his kids, they'll get that 20%, but they're minors. They're going to go through a guardianship in Illinois. So we've already seen a probate in Texas, a probate in Wisconsin. Now we have a probate in Illinois, and we have a guardianship in Illinois. Those things that are supposed to avoid guardianship and probate really don't, or probate anyway. Merlene lost control of 100%. Here is the one bit of good news. When the kids turn 18, they get their share, so they get a really nice car, but probably no college education. Now, Don, he lives in Wisconsin. He's also in his second marriage, kids from a prior marriage, and guess what? His mom didn't like his new wife either. Well, 1/2 of his 1/3 is from right of survivorship, TOD, and POD. So he gets home on Monday, the same day that Norma came to see us. In fact, Norma dropped him and his family off at the airport for them to fly back on her way to see us. He's got a message from the bank. Those things have paid. He needs to open a new account, so he tells them I'll be over tomorrow. But Tuesday, before he leaves the house, he receives divorce papers, and he needs a lawyer, so he spends the day finding a divorce lawyer. What happens to him on Wednesday? Well, he gets the call that Harry died. Now, you can almost understand what Don did, even though I still have a hard time with it. He put his inheritance into a joint account before going to the funeral. In other words, the wife who's suing him for divorce, he puts it in their joint account. Under Wisconsin family law, the wife now gets 1/3 of it. Merlene lost control of 1/6 of what was going to Don. Now, we've got 2 probates, the Texas home and the Wisconsin property, non-liquid assets. So somebody's going to have to put the money up for the probates because there's no financial assets in probate. And they'll have to be paid back from the sales. They're going to have to maintain those properties until sold. Well, that's going to fall on Norma here, and it's going to fall on her, on Don up in Wisconsin. Now, If the husband's name is still on the deed, we're going to have to do an additional probate. But that was not an issue here. However, I've seen that come up enough to know that you ought to be aware of that. One spouse dies, they change the name in the tax records, and they think, oh, we got it done. No, you didn't. Deed records is what you have to go by. And dad's name doesn't get off deed records without some form of probate in most cases. Then it goes 1/3 to each child. Each case is different. So Norma's third worked fine as far as it getting to her, but it wasn't simple. All she got was the assets, no other benefits to her. She had to front the cost for the probates in both states because Harry's estate couldn't assist because of his death. Don couldn't assist because of his divorce. They've got a judge telling them, no, you can't spend money on that probate. That your wife might wind up with that, and how's she going to get paid back? Norma could only be paid back on the sale of the properties. So it could have been a lot worse, but it could have been a whole lot simpler. Harry's 1/3, all the financial assets went to his new wife. 20% goes through probate. 20% will now go through probate on his estate when it, his minor children plus probate on whatever he had. Grandchildren will go through a guardianship to get the non-liquid real estate assets, and they'll have to be sold before they get anything. Then they'll get their share at either 18 or 21 without any other benefits. Merlene lost complete control of the share. It's a complete disaster. Don's soon-to-be ex is going to get 1/6. Remainder comes to him with no other benefits. Overall for Don, it's poor, but it's not the complete disaster of Harry's. What if Merlene had used a trust? There would have been 0 probates. It would have been faster and less expensive sale on both properties. 0 guardianships for minor grandchildren. 100% the benefits after the low cost to those Marlene wanted to see benefit, not people she didn't want to see, like her two soon-to-be, well, her daughters-in-law. Norma's 1/3, she would get part of it from the real estate. All would be protected against a future divorce because Merlene could do that in her trust. All would have been protected from any existing creditors, future lawsuit creditors. Harry's 1/3, 100% to his minor children, no guardianship, controlled by the trust until the grandchildren are older and able to manage on their own. Could have been used for their education and medical expenses. All would be protected against future divorces. All would be protected against any existing creditors and future lawsuits. Don's 1/3 goes 100% to him. His soon-to-be ex-wife would get 0. All would be protected against a future divorce, existing creditors, and future lawsuits. After death, trusts are owned or controlled by the trust, avoiding probate. They provide distribution instructions for all assets. You have faster access to assets. I'll have people tell me, yeah, we left one account out of the trust so we could get to it. Your family won't be able to get to it, and you can get to the assets in the trust. Don't do that to your family. Faster and easier to administer. Fewer complex rules than right of survivorship, beneficiary designations, and probate. If you remember that slide where I showed you the administrative rules, I may have forgotten to point out the trust is by far the simplest way to pass assets. And it involves only one state's law that you can control. Provide more certainty of results than other distribution rules. Okay, so Susan, tell us about these two.
So this is a situation where you've got kids that maybe aren't all on the up and up, and you want to make sure that things are taken care of well. In a situation like this, in this situation, Johnny lived with his mom to supposedly take care of her. Mom dies. He tries to continue to live there rent-free, and he's also using mom's money to pay the expenses like the utilities and those kind of things. In the situation where there's a trust and you've got a wayward child that's really just a freeloader, then you've got the trust is going to have instructions about that kind of situation. It's going to stop that kind of thing. It's going to require him to pay rent, because as soon as mom can decide all day long that she wants to take care of him, but when she's gone, she's no longer the beneficiary of that trust. The children are, whoever she's named as her beneficiaries. And so in this case, Johnny and Jenny are the beneficiaries, and Jenny has been named as the trustee because she's the one that can be trusted to deal with things well. She can, according to the trust terms, require him to pay rent, to pay back any expenses where he used mom's funds, because mom doesn't need the electricity and the water and all of that anymore. And it gives her the leverage to do that. She has, and what would make this even crazier is if there were a third child, she's got a fiduciary duty to all the beneficiaries as the trustee. And so in that fiduciary duty, she absolutely has to ask him to pay rent, to pay his share, because that's the right thing to do for the other beneficiaries. However, in a situation, I've had this come up. I haven't had this situation come up to the point of having this wayward child, but I have had situations where one child spent years taking care of mom in her home, truly taking care of her. And then the siblings are all glad for that sibling to really get the home and get more of the share than maybe the trust even calls for. And there are ways to work around that when you've got cooperative family members. But the important thing with regard to the trust is that when you've got uncooperative family members, you've got rules that the trustee has to follow. And that gives the trustee an out to say, no, I have to do this. This is what mom said. This is how it has to be done. And I've got other beneficiaries that I'm responsible to. And so they've got the legal authority to force things to be done the right way. And so you don't have that when you don't have a trust. You don't have a lot of rules that you don't have a lot of guidance to tell you and require things like this to be done. And so this is a situation where the trust comes in really handy because of the instructions that are in it.
Excellent points. And it might make sense to let that one stay at the home rent-free for a time, because that may just work better, and that isn't necessarily a breach of fiduciary duty. But the trust gives them leverage if one is really trying to take advantage. And my experience is that parents don't want one child to take advantage.
Right.
They want their kids treated fairly. Predator dragons, and I'm going to spend very little time on this. Asset protection, I define as protecting and preserving assets from unnecessary loss. And without going into it, most of our clients do what we call heritage trust, where what they leave their kids is protected. And that's a really good strategy, as you could see when, Don went through a divorce and his wife got part of it. Nobody really wants to see that happen to their kid. So obviously we're not really focused on that, but we do want to wrap up our presentation and give y'all a chance to ask questions. But I'm going to start by turning this over. I'm not sure whether Marty or Sheila will be the one I'm supposed to turn it over to. Sorry, I forgot to find that out.
That's all right. Can you hear me?
Yep.
Great. Sheila, if she's on, we'll have her go over the CEUs again. If not, I'll go over that real quick. Oh, there's Sheila right there.
Yes, I'm here. I don't know why. Oh, my video. You can't see me. Not that it matters. Okay, well, before I do about the CEUs, there's several questions. So can we do the questions first?
However you want to do it.
Okay. All right. First off, Evelyn has a question. And here's what it says. Can you get a guardianship set up when the person is still cognitively intact, but functions between a 9 and 10-year-old due to a TBI? He is now 46 and I am 75. My daughter and I would be the guardians when and if it is needed, if he consents. Oh dear. Okay, hold on. My screen jumped. Hold on. I'm sorry. Hold on. I was right in the middle. Oh, okay. If he consents, I currently have an old financial guardianship. So can they do this, Rex and Susan?
I'm sorry, I missed a piece of that, I think, Sheila. We were trying to unshare the screen.
Okay. It
Yes.
says, I'm gonna read it again. Can you get a guardianship set up when the person is still cognitively intact, but functions at a 9 or 10-year-old level due to a TBI,
Oh,
traumatic brain injury? He
Okay.
is now 46 and I'm 75. My daughter and I would be the guardians when and if needed, if he consents. I currently have an old financial guardianship.
okay. So there are different options there. Depending on his level of capacity, you might be able to stop short of a guardianship and actually do some estate planning documents, powers of attorney, and those kind of things. And so it depends, that's kind of a legal determination of whether he's got the capacity to choose that. There are also some options just short of guardianship where there's a services support document where the person can acknowledge that they want the help, and that's something less than a guardianship. However, if they're functioning at a 9 or 10-year-old level, there's a really good chance that guardianship is what's going to have to be required at that point. And then you need to talk to an attorney. An old guardianship just depends on what that looks like. If it was in place and is still in place, it should work. But without looking at it and knowing more detail, I don't really know the answer to that piece.
Okay, the next question is for Rex. Melissa wants to know, what does overusing mean in this context? And she said in the context of right of survivorship.
Well, the problem with right of survivorship is, first of all, it only applies on death. So if the person becomes incapacitated, you have to go through a guardianship to manage that asset. So if it's a brokerage account or something like that, you're talking guardianship. If the decedent, if the person dies and one of the beneficiaries is incapacitated, they go through a guardianship on their share. If they've died, like what happened with Harry, you don't know where it's going to go because it'll be dependent on their plan. Right of survivorship is, in my opinion, never a good way to pass assets. In beneficiary designations, if it's a beneficiary designation to the trust, that's one thing. But if you leave it to individuals, people have some bad habits. They become incapacitated, they die, they go through divorces, they get sued. There's a lot of things that can go wrong that you have no control over. And call me a control freak, but I have found that most people want their assets to go the way they want them to go and not leave it to chance. It's a great question.
Okay, this next one is for Rex as well. Isabella wants to know, question about the example of Carl. What happens if Peter, Paul, and Mary disagree about dividing the assets after the passing of their parents? For example, one child doesn't want to sell the house, but the other two do.
So if it's after both deaths, those kind of disputes, in my experience, are fairly easy to deal with. One child wants the house, that child gets the house as part of their 1/3. And that doesn't hurt the other two. You just go have the house appraised and that child agrees to pay for it, or they buy out the interest of the others. Now, if you've got to go through probate and sort that out, that's going to be more difficult.
Okay.
But it's fairly easy in a well-done trust.
Okay. Now this is for both of you. Debbie wants to know, does everyone need a trust?
The longer I practice, I have found not one time in my almost 30 years of practice have I had somebody tell me that their plan, that everybody wants to do something that can only be done by trust. We actually have a report we could send out called Does a Trust Make Sense in Texas? 53 things you can do with a trust that you can't do with other estate planning tools. And in all my years, everybody has at least one thing on that list. At least the people who are coming to see us. Now, we're not getting homeless people who live in boxes under bridges, but generally, people who have financial assets, homes, they should be using trust. And that I'm talking about distribution on death. I'm not even talking about what happens on their incapacity. Nobody wants to go through guardianship except attorneys who practice guardianship.
Well, and let me add to that too. If you own real estate, it is highly unlikely that that real estate is going to be transferred without a probate. And so even the simplest of estates, like husband and wife who own a house and a checking account, there are a variety, as many as you can imagine, levels of trusts. But even the most basic trust can avoid guardianship and probate. And so it's always, for me, it's always up to my clients and what gives them peace of mind. But I would say 95% of our clients will go with a trust once they understand what you guys have been taught today. And so, yes, could everybody use a trust? Yes. Does everybody need one? I mean, if they're okay and good with their family going through probate or guardianship, if they become incapacitated, then there are other ways, but they're not as easy on the family. And so that's where I look at it and say, yes, but it's up to the clients and what they need for their peace of mind.
Okay, Denisa wants to know if the appointed trustee or an appointed trustee upon death of the elderly parent is breaching their fiduciary duty, does this require a probate or can other beneficiaries remove that trustee?
It doesn't require a probate per se. The trust terms are going to tell you whether beneficiaries can remove the trustee. We always suggest that there be ways to remove trustees
Without going to court.
Without going to court. And sometimes you need to do that for reasons nobody thinks of. Like I had a case one time where one child was in the military and they get sent overseas to Afghanistan. And then mom decides to sell the house and she needs a signature in, 83 places. But it just wasn't practical. He wasn't doing anything wrong. But we had an easy way to remove him. But definitely if a child is breaching their fiduciary duty, there are ways to remove them. And the easier you make it, the less expensive it is to do it.
Yeah.
And if you're in probate, it's going to be expensive to fix that.
Okay, the next question. If a parent has 3 children, but put down only one child as the beneficiary, however, stated this policy was to pay for her funeral expenses, then split with the other kids. If the one stated as beneficiary decides to keep all the money, is there anything the other siblings can do?
So we see this is part of that very common way to do estate planning. It's not unusual for one child to be the designated responsible child. I'm that in my family, but I've made sure my parents understand that they don't need to do it that way. If you leave, the beneficiary designation passes without probate directly to the beneficiary, and it is legally theirs.
Yeah.
At that point, they don't have to pay the funeral home out of it, and they certainly don't have to divide it among their siblings. What a lot of people, and if I have somebody come in and talk to me, and that's what has already happened, they didn't do their planning with us, and now we're dealing with probate, I will have to tell them as their attorney, that money is yours. Now, most of the time I'm dealing with people that want to do the right thing, but then that's the hard part, is that you've now put that child, that parent has put that child in a position of having to want to do the right thing for mom, but from a legal standpoint, what are the ramifications? And if we're talking about a lot of money, I mean, you can only gift $16,000 a year annually without having to report it to the IRS. If there's more than that for each sibling, then we're creating gift tax issues and forms that have to be filed and all kinds of headaches. And so that is, it is very common for people to do that. They'll put one person on their account for a safety feature to make sure that there's somebody else that can access their assets. But what they don't realize is they've made them a joint owner with right of survivorship. And that very issue is what comes up when they die. And so that is not something that, it's not a good way to plan. You know, if you're going to do survivorship, I mean, if you're going to do designation, then leave it to who you want to leave it to. But a trust can avoid all of that.
And I'll give you, not only are you creating potential gift tax issues, but what if the parent is killed in a car accident, the kid was in the car, and the kid is incapacitated? Right. Now you have this policy that goes to the kid. I can tell you the judge is only going to be looking out for that kid. They are not going to allow it to be used to pay the funeral expenses. They're not going to allow that money to be used because that money now has to take care of that incapacitated person. If that child dies right after, the insurance policy goes to them. Think of what happened with Harry. He died shortly after his mother. Whatever went to him now goes where his plan says it goes, not where mom wanted it to go.
Right.
And people just completely forget that families tend to look at the world the way it is today. It's hard for them to imagine, oh, my brother's not going to die suddenly. The very definition of dying suddenly is you weren't expecting it. You know, that is just a problem you have no control over when you pass things by right of survivorship, beneficiary designations, or TOD. And gift tax issues, let's just say that the parents have a $3 million estate, and right now we've got, I mean, a $3 million life insurance policy, and right now the exemption is $12 million per person. One kid gets the $3 million. They want to give 2/3 of it to their other two siblings. Okay, they just made $1 million gift. They reduced their exemption from 12 million down to 10 million, and it's a little over 12 million. But what happens when Congress comes along and they reduce that exemption to, let's say, $2 million? Poof. Everything they have is now subject to estate tax.
When they pass away.
Yeah. So
the long-term effects are, it's just not, it's not worth it.
You have no idea what will happen. And Congress can change the law. They're prone to doing that. The state legislature can change the law. You know, our state legislature meets for 140 days every 2 years instead of 2 days every 140 years, like I think they should meet. But that's the problem. When Congress or the legislature is in session, your life and your possessions are in danger.
Can I ask you a quick question about income tax on a trust versus the income tax you would have if you didn't put it in a trust? Is the income that's made on a trust just all taxed personally as passed through to the beneficiary?
So in a what is called a grantor trust, the person who sets it up pays income tax at their ordinary income tax rate. There's no separate trust rate. The only way that trusts ever pay taxes is if the trust generates income that it doesn't distribute. And in my almost 30 years, I've seen that come up less than 5 times. So there's usually, if you're using an irrevocable trust, it's a non-grantor trust, there's a plan for getting the income out. Or I have occasionally seen cases where they chose to pay some income tax through the trust to avoid another problem. Like if you have a child that gets sued and the option is to pay the IRS 37% or their creditor 100%, hey, you may not like the IRS, but it beats the heck out of paying it to the creditor. So normally, normal trust that we use regularly, there's not a separate income tax rate for them. It's just the individuals.
And to follow up on that, then, if you put real estate in that trust and real estate that a person owns, the basis of it adjusts upon death, correct? To the
That's
market
correct.
value. How does the basis work within a trust? Does that basis still adjust?
Yes, it does.
And in
Yep.
case there's anybody out there that doesn't know what basis is, that really is about what kind of taxes you pay when you sell something. So if you buy a piece of land for $100,000 and you sell it a few years later for $200,000, you've got a capital gain of $100,000 and you're going to pay some taxes on that. If you, and there was a question in here about should we, is it easier for a parent to change ownership while they're alive? And the answer to that is no, because of that very thing. When you change ownership like that, the basis stays at what the parent purchased it at. So let's say the parent purchased it at $100,000, gives it to the child, and then the child sells it for $200,000. They're going to have $100,000 of capital gains that are going to have taxes. But if the parent waits and it's transferred on death as an inheritance, then they get a step up in basis. And so at the time that the parent dies, if it's worth $200,000, that's the new basis. And so then when the kids go to sell it right after death, there is no capital gain because they get to start at $200,000. And if they wait a little while and it goes up to $300,000, they're only paying taxes on that extra $100,000, not going all the way back to the purchase price of the parent. And so you don't want to gift it because you don't get that step up in basis when you gift.
Okay, next, your thoughts on the same subject, your thoughts on transfer on death deeds and ladybird deeds.
Nowhere near as efficient as using a trust, and can have consequences people never anticipated. With a trust, you know exactly what will happen if you get somebody who can do the trust correctly anyway.
Well, and they still have the same issues as designating it's just designating a beneficiary on land. So it's the same issues that we've talked about with regard to right of survivorship and beneficiary designations. You can have all those same issues with a piece of real property.
Yep, that transfer on death beneficiary, if they've died or become incapacitated, you just created more work for
attorneys to make
money, honestly. And we do that kind of work, so I hate to complain about it, but I hate seeing people put their family through probates and guardianships that could have been so easily avoided because they're so much more expensive than doing a trust right.
Next, is it possible to become my deceased mother's executor who had no will? My father is alive, but is suffering from Parkinson's and the beginning stages of dementia. I see that there's a lot of work to do. Thank you so much for sharing this information.
And the answer to that is absolutely. We do probates, whether it's probate of a will, you can probate a will, and if an estate doesn't have, if a person doesn't have a will, then the state of Texas has created one for you, and that can be probated as well. While the surviving spouse is first in line to serve in that role, if they're not able, then there's a long list of who is eligible after that, and it's not difficult. If we've got an incapacity issue, then we deal with that as we need to. But yes, the estate can be and needs to be probated, because if you wait, if they own real property when your father passes away, then there's going to be two probates, and the farther out you are from the death, the more difficult the probate becomes, and you want to try and get that done as quickly as you can. But it's never too late to do something.
Yeah.
I'm going to share my screen, so we can go back over the CEU stuff. I think we've answered all the questions. Am I correct? Okay, so we're good. Let me see if I can share my screen and get to the,
I see one more question, if I may.
yeah, go right ahead.
A couple of questions. People have asked about the average cost of a trust. That's kind of hard because that's like asking what's the average cost of a house. Are you talking about a 3-bedroom, 2-bath, 1-car garage? Are you talking about a 7-bedroom, 5-bath, 4-car garage? I mean, you're going to get what you pay for. And generally, there's just no comparison between a $1,500 trust and an $8,000 trust. The $8,000 trust typically is going to do way more things. So it's important that you really nail down what you're trying to accomplish. We have a lot of information we're happy to send, but we don't typically share fee information because we have fees all over the board depending on what people want to do. But
And because we're not selling anything, this is
Right.
just education.
Exactly.
But we do have a lot of material that will tell you things you probably ought to be looking for in your trust.
Yeah,
We'll
the
share
answer
for
to
free.
that is you're just gonna have to check with an attorney and ask them, you know, they're gonna have to probably go through an intake and talk about what you're needing done in order to really give you an idea of the
Yeah.
cost
Exactly.
you're gonna need. You know, you're welcome to call Haven Hope, you're welcome to call any other attorney that handles trust
That's exactly right.
and estates and that type of thing. Can you see are you seeing the CEU information? 'Cause
Yeah.
My screen got screwed up when I shared it. Okay, Sheila, I'm gonna let you go over that if you would.
Okay, because I have had a couple more questions about it.
Okay.
Okay, Marty will email you the 3 documents. A disclosure statement that says that Heyman Hogue does this for a living, but this was strictly educational event. We are not trying to sell anybody anything, even our services, nothing. Okay. B, you do not return that to me. That is strictly for your records. B, there is a sign-in and an eval, which all of you are used to doing when you get CEU credit. If you will fill those out and return them to me, then I will be more than happy to send you your certificate.
Additionally, there usually is a Google survey that pops up as you sign out on Zoom today. It will not be there today, and I certainly apologize for that. And I apologize for the screw up. For those of you that got on late, I just totally screwed up this morning. I'm sorry for the hassle in getting your links to you. I, for some reason, had in my head that this was going on at 2 o'clock today, and I just totally messed up. I'm sorry. But I will be sending the Google survey evaluation out with the first follow-up email with Sheila's documents. Please fill that out. That helps us to report back on our goals and objectives set forth in doing these webinars when we apply for the funding. So I'm going to stop sharing and let you. We're going to go back and answer the last question if you said there's a couple.
I think, have we covered everything, Sheila?
I think so. It's just thank you for sharing this information. And Melissa says, please repeat this workshop when you can. It's good material. Thank you, Melissa. That's very kind.
And Melissa, just so you know, that there will be a recording of today's webinar that will be posted to our YouTube channel. And you will receive a link to that in a second follow-up email that we send out once that this video is processed and uploaded to our YouTube channel. So you look forward to that. Rex, Susan, thank you so very much. Sheila, thank you very, very much.
Thank you, guys.
You're welcome.
That's an information.
Everybody have a Merry Christmas.
Thank you, but even the presentation, it's the style and everything just really, really helpful. Thank you so much.
Absolutely.
You're welcome.
Y'all take care.
And I apologize to y'all about this morning. Y'all have a wonderful day.
No worries.
Okay.